along. I was moving on to the third point, and that is the fate of the counterclaim in the event that the appellants fail on ground 1 of the appeal. My submissions in this were set out in my first skeleton argument. If I can take you to page 23 of the main bundle, paragraphs 8 and 9, which are preliminary.
Yeah.
And the reason for taking to those paragraphs is essentially because of paragraph 9, which explains, it's a point that was covered actually this morning, that as a matter of English property law, one person cannot hold as agent or nominee for another. That's a legal concept that just doesn't exist except by analogy. And the reason for that is that in circumstances where one person is holding land for another, the appropriate, in fact, the only legal mechanism that comes into play is the mechanism of a trust.
I think you say later it doesn't make any difference.
I do, well, as with all of these things, there may be some differences in nuance, but the analogy should be a pretty close one.
Yeah. I suppose one difference is if it's a trust, it is a trust of land within Tolata and brings in all the Tolata provisions. So
but all that does essentially is reflect what the position would be if there was an agency.
yes.
Because if there, before the judge, and also I think in resisting permission, the application for permission to appeal on ground 2, the point that was taken by the respondents is that seemed to be that they held the property under some kind of agency, and that agency still had the characteristics described in the Sylvan case.
Yes.
Which is, well, if they want to explain that, they can, but I'd suggest that's a very odd approach to take for 2 reasons. First of all, as I say, because the House of Lords has held in terms that although under Scots law, A can hold land as a nominee for B, as a matter of English law, A has to hold as trustee for B. So the agency approach is never the strictly correct way of looking at it, although, as I say, there are analogies. The second point, though, is this. The receivership came to an end when the charge was redeemed. So even if it were right to use the Sylvan approach while the respondents were receivers appointed by the charge, the position on redemption of the charge would have to be, yes, they hold it as receivers, as they hold it as agents, but they now hold it under a bare agency. And that's the reason why this is relevant, is because when one looks at what happened in relation to the application for license to assign, it is clear that the defendants were purporting to act essentially as principals. They thought it was their decision whether or not the property should be assigned. They thought it was their decision who that assignee should be. And they regarded the role of the appellants as being simply that of landlord under the lease, seeking their consent. Now, as I take you to paragraphs 8 and 9, can I now take you to paragraph 27, which is starts on page 35. And 27 is broken down into 3 parts. One is if it's right to say the defendants hold the lease as agents. The second is if they hold as nominee, as let's say both of those would be inconsistent with the House of Lords decision in Ingram. And so we then get to, once it's under, this is paragraph C, once it's understood the defendants hold as trustees, then the position is as follows. And I say in C3 that the defendant's sole function as bare trustees is to hold the lease until such time as the claimant directs them to convey it. No such direction has been issued. In the circumstances, they have no duty to remain like a mere
Which
name.
raises a big question, which is, why on earth not? You say that the receivers hold the CP lease on bare trust for you. Therefore, you could call upon them to hand it back or to your nominee.
Yes.
But you haven't.
No, indeed we haven't. That's right.
Why not?
And the question is with respect irrelevant, but I don't know what there in the evidence. There is no explanation of why not.
But why do we have to have an application for specific performance and then an appeal to this court in circumstances where, on your analysis, your clients have got a self-help remedy which solves all the problems?
Well, with respect, this third point only arises if the claimants lose on the first point.
Right.
So if the claimants are right in the first point, then the claim is one for specific performance. If we lose on the first point, the position then is that we're not entitled to specific performance, the reason being that the respondents hold the property on trust for us. What the judge has held by his declaration is that consent has been unreasonably withheld and essentially that they are entitled to assign, to proceed with the assignment to NTRML, notwithstanding the fact we haven't given consent.
Okay, but then you're effectively saying that that decision is wrong for a different reason.
Absolutely. What I say is having what we're looking essentially is what the decision tree or flow chart, however you want to describe it, should be as applied to this claim. And the point is this: as soon as it is held that the lease was acquired pursuant to a right conferred by the charge, what that tells us is that the counterclaim has no merit. And the reason the counterclaim has no merit is because you've got one person who is bound to comply, who's statutorily bound to comply with the wishes of another person. The person who is bound asserts a right which the other resists, and then brings litigation to vindicate that alleged right. But this is something where, as soon as it's understood that the respondents hold as trustee, one says this counterclaim must be dismissed.
Yes, but that was never your client's position in the court below. You didn't say, well, if it's right that the receivers acquired the CP lease in the exercise of their powers as receivers, then the CP lease is held on trust, and in what's more, in those circumstances, we're entitled to direct that it be conveyed back to us or to our nominee, and therefore this counterclaim has no point.
I wasn't present at the trial. I didn't conduct the trial.
But your clients didn't make
But I did draft the statements of case. Can I take you, because it said that this is the first time this point has been raised. It isn't.
All right.
Can I take you, please, to, if we go to page 115, we start off with the defendant's pleaded case. In paragraph 33, they aver that they acquired the right, the lease in furtherance of their receivership duties. That's paragraph 33. In paragraph 37, they assert they say that they did so as agents for the claimant. That's page 100, paragraph 160. There is no alternative case they hold as trustees. So the case they're asserting is one that actually isn't known to the law of England and Wales. But they also, if we go back to paragraphs 113 and 114, they assert their rights in relation to the application of the licence to assign.
Sorry, 100.
So it's page 113.
Oh,
please.
pages.
I'm sorry, I do apologise. It's paragraphs 21, 22, well, 21 to 26, but 21 to 23 are the important ones. So this is where they set out the application of the licence to assign and assert that consent was unreasonably withheld, and by reason of the unreasonable withholding, they're entitled to assign the lease. The response to that, and that's in the defence counterclaim. If I could now take you please to page 129, which is the reply in defence counterclaim. And it's really subparagraph C, if I could ask you to read that to yourself.
Sorry, which page or which paragraph?
I'm on page 129 of the bundle.
Thank you.
This is within the reply and defence counterclaim, and it's paragraph 15 sub C. Now, I accept this averment is made in a slightly different context, but it cannot be said that, that the argument of a trust was first raised on appeal, nor can it be said that...
I'm sorry, I'm struggling to understand this, because this seems to be all about the receiver's state of mind.
It did, it did.
I mean, we have 3 references to genuine belief.
Yes.
So it's all about their state of mind, not about the objective legal analysis and the consequences thereof.
Okay, if we can pause there for a moment, then we have to remind ourselves that on the documents, it is clear that the defendants are the registered proprietors of the common parts lease. It therefore follows that unless they can point to some reason why the tenant covenants in that lease are non-justiciable against them, unless they can do that, we are entitled to judgment on the covenants in the lease. What they could have done, what the defendants could have done, they could have said, we hold as agents, and that's what they did. And of course, the problem with that is that averment is one that couldn't possibly succeed as a matter of law. But what they don't say is that in the alternative, if we didn't hold as agents, we held as trustees. In other words, the trusteeship is a point that the defendants should have pleaded, not the claimant. This is something which the defendants who are saying, by reason of the basis on which we hold the lease, we're not liable under its covenants, or the covenants shouldn't be enforced against.
I'm sorry, but why should they be under an obligation to plead something that they didn't legally accept to be the case? You say they were wrong in law, but I'm struggling to understand that there's an obligation to plead something that you say is wrong. That the party...
No, I'm sorry.
Sorry, the word "you" there is ambiguous. I apologise. Let me try and clarify my question. Why is a party obliged to plead an assertion which that party contends to be wrong as a matter of law, even if it turns out that they are themselves wrong?
Well, what I'd suggest is this. In a case where someone is, on the documents, liable under a covenant, and they wish to say that they have a relationship with the person who has the benefit of that covenant, such as to make that right in some way non-justiciable, then what they have to do is they certainly have to plead the facts which establish the existence of that relationship.
I'm sorry to interrupt you, but you've twice used the expression non-justiciable, and I'm utterly baffled as to what you mean by that.
Right. What I mean
because I don't think anybody's contending that there is some issue in this proceeding which the court is incapable of ruling upon, are they?
So I was using the language of Ingram. I apologise. The point essentially is this: if a trustee, we'll use a trustee as if we start off with an agent. If an agent,
I'm sorry to interrupt you again. I do apologise for this because we've got away from what we were on, and please do develop your submissions in a moment. But where all of this started was with a different question which I was asking you, which is about your client's stance, and in response to that, your immediate reply was to say, we pleaded this, and you've taken us to something that, as I see it at the moment, doesn't quite go there, because what I thought you were going to take me to was something in the reply and defence to counterclaim that said something along the following lines: the correct analysis is that if, contrary to the claimant's case, the defendants acquired the CP lease in the exercise of their powers under the charge, then they did so as trustees, and it then follows that, upon that hypothesis, this counterclaim should not be maintained because it's a pointless exercise. And at the moment, I am not finding that in the reply and defence to counterclaim.
Right.
If there's something which you say is there to that effect, then please could you show it?
Well, okay, maybe I misunderstood the question. The point that has been taken by the defendant, including in all its skeleton arguments in this court, is that the trustee point had not been raised before, and that nor had the inability, nor had the what I'll call the paramount importance of the trustee, of the beneficiary's wishes being raised. Now, that has been raised. I accept it's raised in an oblique sense. I do accept that. But we all know that statements of case are not there to plead points of law, and therefore it was not necessary for the defendant actually to plead out what the legal consequences would be of the defendant's factual case. All that was necessary in a reply and defence to counterclaim was for joinder to be for there to be joinder of issue, and that's what happened.
All right, thank you.
However, when we look at my learned friend's most recent submissions, the impression I get, and maybe I'm wrong, in which case I apologise and I will deal with this in reply, but the impression I get is it's now conceded that if the first issue is decided against the claimant, then the property was held as trustee. And that's a long way from the base on which it resisted the application for permission to appeal in relation to issue number 2. A very long way.
Well, but as I read it, the argument for the respondents argues in effect that the consequences of the trust-based analysis are different to the consequences for which you are. So you may be right to say that they don't dispute the trust-based analysis,
absolutely.
but they say it has different consequences.
And that's what I'm now turning to. And the reason for that difference, and this again is a point that was raised this morning, is that the respondents assert that as trustees they are not under any obligation to comply with any direction given by the beneficiary, except in relation to directions as to a transfer of the property. And they get that. This is paragraph 19 of the respondent supplemental submissions on page 218. And they get that from the judgment of Lord Justice Millett, as he then was, in the Ingram case. Which is behind tab 9.
Yes, but just before we get into it,
Yes.
can I be clear? When I asked you earlier, I didn't understand you dispute that the consequence of the trust-based analysis is that your clients could direct the receivers to transfer the CP lease to themselves or to a nominee. Right.
They accept that's a consequence, but they say that that is the only consequence of the trust.
Yeah, but that point is common ground. Yeah. And then the question that you're about to address is whether that's the only.
Absolutely. And they base this submission on the judgment of Lord Justice Millett in the Ingram case at page 424, letter D. So it's behind tab 9. And it's the internal numbering is 424D, so it's on page 148 of the bundle, if that's any assistance. And it's the paragraph, it is important not to understate, is the paragraph that they are referring to. And there are really, as we see, that there are essentially two propositions being made by the learned Lord Justice in that paragraph. The first is that as trustee, his duty was, quote, to deal with the land as Lady Ingram might direct. That's a reference to the provision of the relevant trust deed. Now, the expression deal there is used in the sense of dispositions. He's not dealing with management. And so he goes on to say he was bound to convey the land to her or to whom she might direct. And that's what is implied within. That's what is meant by an obligation to deal with the land as she might direct. But before we go to the second point, there's a point worth noting. If there's an obligation to deal as someone might direct, that brings with it an obligation not to deal with the land otherwise than that person may direct. In other words, if I am a bare trustee, for example, yes, I'm under a duty, if the relevant deed so provides, to transfer it or to grant a lease of it or whatever, as the beneficiary may direct. But in the absence of such a direction, my obligation is simply to sit on the property, to hold it.
Well, that is subject to Talata, isn't
No,
it?
absolutely,
As we discussed earlier, so section 6.
Absolutely
will
right.
impact on that.
And that comes back to the point that we were dealing with this morning, which is that this statement of Lord Justice Millett, however right it was in relation to the position before the 1st of January 1997, is actually not a point that can be relied upon by the respondents, because the law, as stated by Lord Justice Millett, was changed by the 1996
Well,
Act.
it can't be relied on insofar as the law was changed.
That's right. And so this is the paragraph that's relied upon, and as Lord Justice Millett says, he was not bound, that its trustee is not bound to comply with other directions, that is, directions otherwise than as to dealings with the property. And that is, as I understand my learned friend's skeleton argument, that is the sole basis for their contentions. And the problem is it's fundamentally misconceived. And the reason it's fundamentally misconceived is that although Lord Justice Millett correctly stated the law as it stood at the date of the transaction he was considering, we now have the Trust of Land and Appointed Trustees Act. I've already taken you to sections 6 and 11. We've seen that section 6 is essentially a provision which is for the protection of disponees, although it has other, it may well have other significance as well. But the relevant provision, or the most important provision here, is section, that's section 6, is section 11, which by subsection 1b provides that the trustees of land shall, in the exercise of any function relating to land, so this isn't simply disposals, this is any function, ... be, so far as consistent with the general interest of the trust, give effect to the wishes of those beneficiaries, or in the case of dispute, of the majority, according to the value of their interests. Well, this is
so it's not just have regard to, consult,
sorry.
have regard to, it's give effect to.
Yes, sorry, it's give effect to, you're correct, absolutely. And so we have a situation where we know, or by the time we get to this point in the flow diagram, we know that the defendants hold the property as trustee. We know that they hold it as bare trustee. We know that the beneficiary under that bare trust is the claimant, the appellant. It follows that in the exercise of any powers they have as trustee.
But I don't understand that, because they don't have any powers. They're bare trustees.
Well, they've got power to bring proceedings. They've got power to dispose of land. They've got power to manage land. They've got power to carry out inspections of the property. They've got a whole range of functions in relation to the property.
Does that mean that if we're in this part of the flow diagram, you can effectively achieve the same as specific performance by giving them directions to carry out works?
Well, the answer is a qualified yes. I'm sorry, I never give straight answers, and I do apologise for that. But in a sense, the answer would be yes. In a sense, they'd be acting in breach of trust if they didn't, as well as in breach of contract. But of course, any trustee who found that unpalatable would simply give notice under Section 6 too.
Yes.
Saying, I don't want to do that, take the property back.
And also, trustees are not obliged, unless they're in breach of trust, to put their hands in their own pockets. So you might have to provide them with the money up front to do that.
Absolutely. And that's why, as I say, that there are these, it is only so far as with the general interest of the trust. And so if the position were that the beneficiaries wished the trustee to do something for which there were insufficient assets, then that would justify a refusal by the trustee, because it would be inconsistent with the general interests of the trust.
Yes.
But what we're looking at here is this. There is a cause of action which the defendants, as tenant under the lease, and as have against their landlord. They hold that lease on trust for that same landlord. In those circumstances, if their landlord, the beneficiary, intimates to them that these proceedings should not be issued or proceeded with, then the trustees are under a statutory duty, unless it's against the interest of the trust, not to bring the proceedings or to cease
But that's
it.
why I'm struggling to understand why we don't find in the reply in defence to counterclaim saying, by virtue of our power under section 11(1)(b) to LASA, we direct that this counterclaim be discontinued, or correspondence.
Well, the reason I suspect is this. this was litigation that involved a number of moving parts. At the time of drafting that, I suspect the view that was taken was that it was a counterclaim would only be pursued if it was established, or to the extent it was established, that the lease was held by the defendants as principals. Because anything other than that would have been extraordinary. But the extraordinary then happened. And the point that I'm raising here is actually very similar to a point that was raised when seeking, when dealing with the second hearing in front of the judge. I wasn't there, but this is a point. It was approached in the using the agency analogy rather than the true trust analysis. But the point was raised before the judge, but he didn't like it. So I say that what I say is that the judge, having held that the property was held on trust, should simply dismiss the counterclaim. The reason for that being that prosecution of the counterclaim is itself a breach of trust. Having held that the CP lease is a trust asset. Although my skeleton argument addressing this point deals with the 1996 Act, and my learned friend's skeleton argument doesn't address the Act at all, so I don't really know what his submissions are on it. And with that in mind, I don't really propose saying anything more at this stage.
All right.
That being the case, I pass to the fourth point, and as I've already indicated, you'll recall that the issue on the fourth point is that if we succeed on the first point, then they say the judge should have granted a declaration saying that they're entitled to assign the lease to NTR. In order to do that, and the judge made findings of fact, he found as a fact that it would have been that a reasonable person might well have refused consent. And so my learned friend has to get past that finding of fact. With that in mind, I propose to confine myself to dealing with points in reply on that.
Yes, very good.
That being the case, those are my submissions at this stage, unless you've got any questions.
No, thank you very much. Mr. Roses.
Thank you, my lord. May I just begin by going back to a point that was raised at the very start of the morning by my Lord Justice Nugee on housekeeping. I just make this now in case I forget during the course of my submissions. This is the point about plans. I have asked for plans to be produced for the court because we say that it is relevant for the court to see them. It's relevant principally in the context of specific performance. And I say that for this reason. Under the common parts lease, it's not quite right to say that no parts of the structure of the building were demised. The roof, as the judge notes, albeit only in passing, was demised. The external walls were not demised. And that is relevant in relation to specific performance because the claim for specific performance was in respect of very broadly two heads of work. One was to fix the roof and the other was to fix problems with the external render on the walls. And so one aspect of the specific performance claim related to a part of the building that was demised by the common parts lease, the other didn't. and my learned friend took the court to the definition of the demise in the schedule to the common parts lease. There is no reference to the roof there. The reason that the way we see that the roof is demised is that there are approximately 7 plans within the lease, and one of those plans is labelled roof and it is edged in red, and the demise extends to all parts edged in red. So I will arrange for the plans to be produced for that purpose, and I'll develop the relevance of that when I come on to the specific performance point.
From what you've just said, it sounds like we only need one of the plans.
Well, you
But
probably do.
I'll leave that to your judgment.
So, if I may go back to ground 1, where my learned friend argues that the judge was wrong to hold that the defendants were acting within their powers as receivers of the claimant's freehold interest in applying for and obtaining a vesting order in respect of the common parts lease. And the court was taken to the relevant part of the commercial mortgage conditions. If I could ask you to please open that up again so that we have it in front of us. It's in the supplemental bundle at page 221. Clause 15.4. And I just begin by drawing your attention to the opening part of 15.4, which says that every receiver shall, subject to restrictions, etc., have and be entitled to exercise in relation to any asset which is secured in favour of the lender in respect of which he was appointed the following powers. And the powers at Little Roman 2 under Schedule 1 to the Insolvency Act are then engaged. And before we get to that, a point was raised below about that phrase, in relation to any asset which is secured, etc. And as the judge said at paragraph 110, obtaining a lease of part of the charged property was clearly something that was done in relation to that property, namely the secured asset. The reason I make that point in the context of the appeal, it's not a point that's taken on appeal, it is because it's relevant for the distinction that Mr Dutton draws in a number of respects between the security that was taken, namely that over the freehold, and the security that wasn't taken but he says ought to have been, namely a charge over the common parts lease. And I deal with that in this way. I just make 2 points on that. First of all, we say that distinction is irrelevant to the question of whether the powers under the mortgage conditions entitled the receivers to apply for the vesting order. It can't be an answer to say that the lender could have sought a charge over the common parts lease as well as the freehold, which would have enabled it to take possession when interpreting the powers under Clause 15.4 and Schedule 1 to the Insolvency Act. But secondly, and in any event, we say it's fanciful to suggest that a lender would take a charge over the common parts lease as security, for the simple reason there is no value in the common parts lease. The freeholder polices its enforcement, and as an asset, it simply has no value at all as security. So I make those points as preliminary points. I then come to the first of the powers on which we rely and the one on which the judge relied, which is paragraph 17 of Schedule 1 to the Insolvency Act, and that is in the authorities bundle at tab 19, page 238. Now, before I descend into the minutiae of the points that my learned friend makes about the language, I make a general point on interpretation, which is that we are here interpreting the provisions in legislation that was enacted to confer powers on administrative receivers. And those powers ought to be interpreted in a broad, common sense way which supports the purpose of the appointment of an administrative receiver. And we say that the submissions that the appellant makes on paragraph 17 and the powers in Schedule 1 generally involves unnecessary restrictions on the language used. So the submissions that Mr Dutton makes about paragraph 17, they're not arguments that were put below. I don't say it's not open to him to run them, but it's interesting just to note in passing that what was said, two things essentially were said below. First of all, on paragraph 17, it was said that applying for and obtaining a vesting order was not taking a lease of property, and the judge rejected that. And it was also said that obtaining the vesting order wasn't necessary or wasn't required or convenient for the business of the property. And again, at paragraph 112 of the judgment, that the judge rejected that. He held that taking a vesting of the common parts lease was important for preserving the value of the freehold, and that fell within that rubric. But what Alma did not contend below was that the common parts lease was not property that fell within the meaning of this power. But the judge clearly had no difficulty in holding that the common parts lease was within the scope of paragraph 17. And we say, for the reasons I'm now going to address, that he was quite right to do so. So turning to the points that my learned friend makes on the language of paragraph 17, his first point is that the reference to property is property which is required to be physically occupied by the receiver. Now, in fairness, I think in his oral submissions, my friend accepted that that's not one of his strongest points. And no doubt that is a scenario where the receiver's looking to take a lease of property for the purpose of occupying it in connection with the business of the company that will often arise. But there's no warrant in the language which requires that as an implied limitation on the paragraph 17 powers. There's no objective reason to attribute that intention to Parliament in conferring powers on administrative receivers. These powers are framed in the widest possible terms, and there's no reason for artificially restricting them. And I was, as one does, just trying to think of other scenarios that might arise where it's taking a lease of property would fall within the scope of this power, where it's not intended to physically occupy it. And one that readily came to mind is where the business of the company is an investment business, and in order to continue to run that business, the receivers acquire a lease of some other property, not for occupation, but to derive an income from it. That we say would clearly fall within the scope of Part 2 of paragraph 17. And that is not restricted by physical occupation. So we say that is one limit that the appellants rely on, which simply isn't warranted by the language or the purpose of the provisions. The next point that is made draws on a distinction between the first and the second part of paragraph 17. The first part refers to property of the company, and the second part refers to any property. And in fairness, I don't think this was particularly pressed in my learned friend's oral submissions, but it is a point in his skeleton argument. And the argument is made that in the second part, the power is not dealing with property that is within the ownership of the company, but some other property. I'll come on in my third point to deal with the positioning of the word any. But wherever the word any is positioned, its meaning is broad, and we say defeats an argument that there is a distinction between the property of the company in the first part of paragraph 17 and the property that is referred to in the second part of paragraph 17. Any property means, we say, just that, and it can refer to any property, including where it arises, the property of the company. The real distinction between the two parts is that the first part is dealing with granting or accepting a surrender of a lease, and the second part is relating to taking a lease. That's the distinction between the two parts. It's not between property of the company on the one hand and some other property on the other. And that argument involves, again, writing words in to paragraph 17 that aren't there and aren't warranted, namely the word other. Now, as my learned friend's oral submissions were developed, the main point that really emerged, it seems, is this point about the placement of the word any, and the question of what has to be required or convenient for the business of the company. Now, we say that it would make no difference to the wording of this provision if any were shifted 4 words backwards so that it replaces the word a before lease or tenancy, or if it remains where it is. The meaning would still be the same, we say. And what is required, what is to be required or convenient for the business of the company is the composite phrase, a lease or tenancy of any property. That, we submit, is a natural reading. It gives effect to what ought to be the broad purpose of this and the other powers in the schedule. And, if applied, clearly encompasses the act that these receivers took of applying for and obtaining a vesting of the disclaimed common parts lease. And before I leave paragraph 17 and go to my respondent's notice points, going back again to the distinction between the first part and the second part of paragraph 17, the appellant must accept, we would say, that under the first part, once the common parts lease had been disclaimed and the right to possession of the common parts of the building that were demised reverted to the freeholder, the receivers had power under the first part to grant a new common parts lease to a nominee company, which, incidentally, on the facts, was one of the options that was under consideration at the time.
Sorry, I may have misunderstood what you're saying here, but I'm a little puzzled because does this question not only arise after the making of the vesting order? In which case, how does that hypothesis work?
No, it doesn't arise after making the vesting order. This is the scenario that I'm looking at, is before any vesting order is sought, the common parts lease has been disclaimed and therefore, yes, as discussed this morning, doesn't exist as against the freeholder. And so the right to possession of the common parts is therefore vested in the freeholder, absent the common parts lease. And so the receivers acting on behalf of the freeholder can grant a new lease, not the revival of the old common parts lease, but can grant a new lease on identical terms to a nominee.
All right, but I'm still struggling because you seem to be addressing a hypothetical which is not the facts of our case.
Yeah, indeed. I'm addressing it to demonstrate why we say there is an absurdity in the interpretation that the appellants advance.
So you're asking us to assume that hypothetical and then go on. Right.
Yes. So factually to assume it, yes. Yeah. So that is a scenario that could have arisen. Had it arisen, the receivers would have had the power under the first part of paragraph 17 to do just that. And in fact, this was noted by the judge. It might be worth opening up the judgment in the core bundle, paragraph 113 on page 72, at the bottom of the page.
I beg your pardon, I didn't follow the reference.
Page 72 of the core bundle. Paragraph 113.
Yeah.
And the judge, in effect, makes the point that I'm making. The artificiality of the argument of the claimant that taking a vesting order was not within the power of the defendants as receivers is demonstrated by that's the claimant's acceptance that the defendants would have had the power to create a new common parts lease. The claimant's suggested conclusion, namely that defendants were acting outside the scope of their authority, would also be extraordinary if the common parts included the roof happened to become key to a profitable redevelopment of the building, etc. But that first point is, in effect, the point that I'm advancing to this court. And it's noted by the judge that was a point that was accepted by Alma below. And once that point is accepted, it demonstrates, we say, the absurdity of the argument that applying for a vesting order in respect of the previous or the pre-existing common parts lease can't be within the second part of paragraph 17. So, my lords, that's what I say about paragraph 17.
I thought there was a grammatical point taken by Mr. Dutton that required or convenient qualifies property rather than lease.
Well, my answer to that, but perhaps I didn't make it clear what I was addressing. I think it was a number of points in one. It is my point that required or convenient qualifies a lease or tenancy of any property. It's the composite phrase which it qualifies, not one part of it or the other.
Okay.
And so read in that way, it gives effect to what we say is that the purpose to confer broad powers to achieve the objects of an administrative receivership. And it fits with the grammar and the syntax of the paragraph.
I think that was a point you made. I just failed to appreciate. I'm sorry.
Thank you. My fault, I'm sure. So that's what we say about paragraph 17. If we're wrong on that, then we rely on the respondent's notice. I ought to address Mr. Dutton's point that I haven't pleaded my case properly in the respondent's notice. If it is necessary for me to say which powers the application of either paragraph 23 or clause 15.4 Roman 4a are incidental to, then I haven't done that, and I'm very happy to apply to amend to do that. But we say that isn't necessary because, as your lordship indicated, it is obvious that we are not asserting that it's incidental to paragraph 17 because this only arises if paragraph 17 doesn't apply. And so it must be incidental to other powers within the list. It's not just the list in Schedule 1. It's also, so far as the contractual clause is concerned, other powers in Clause 15.4. But we rely principally on paragraph 2 of Schedule 1 and also paragraphs 12 and 14. Now, on the question of whether applying for and obtaining a vesting of the common parts lease is, using the language of paragraph 23, incidental to the exercise of those powers, or using the language, adopting the language of clause 15.4.4a, whether it is incidental or conducive to any of the functions or powers of the receivers. The judge made a finding at paragraph 112 in the judgment. I think that page ought still to be open. In connection with the phrase required or convenient with the for the business of the company, that taking the common parts lease was essential to preserving the value of the freehold. And in his oral submissions this morning, my learned friend, I think, accepted that as a factual proposition, and we would suggest that there's no basis for arguing otherwise. When one looks at the structure, in order to either run the business of the company, which, as was indicated this morning, is holding the freehold of the property, or for the purpose of realising that asset, the freehold of the company, as the judge held, it is essential to have the common parts lease in place. It is an essential piece of the machinery. And so if it's right that the action that was taken in obtaining a vesting of that lease doesn't fall within the specific power, it clearly, we say, is incidental to the exercise of the power in paragraph 2 to sell or dispose of the property, or alternatively, in paragraph 12 and flowing from paragraph 2, things necessary for the realisation of the property, or alternatively, paragraph 14, carrying on the business of the company. And then the final point I make about that, about the general powers referred to in the respondent's notice, is a small point, but one I think worth making anyway, in relation to the contractual power in clause 15.4.4a, which is that the decision as to whether a step that is being taken is incidental or conducive to other powers is that of the receivers. It arises where it is a matter that seems to the receiver to be incidental or conducive to. And on the evidence, in this case, the receivers gave evidence of the legal advice that they received, and it's recorded in the judgment, and there was no dispute about it. And based on that legal advice, they formed the view that taking the common parts lease was incidental to the exercise of their functions. There were other possibilities that were floated, and I think there was some reference to this in the judgment this morning. It was suggested that they might apply to restore the original lessee of the common parts lease to the register. They might seek to have the lease vested in a nominee company, but for whatever reason, good or bad, they they followed the legal advice that they were given to make the application in their own names in their capacity as receivers, and that's what they did, and they obtained the vesting order that the court was shown this morning. So we say that under any one of those provisions that we've relied on, the receivers did have the power to take the steps that they did, and therefore the action that they took was within the scope of their powers as receivers. And we, on that basis, invite the court to dismiss ground 1 of the appeal.
Just before you leave ground 1, can we go back and have another look at the vesting order itself?
Yes. It's in the supplemental bundle behind tab 7.
Page 226.
Yes.
And then there's a list of land and property disclaimed by the Crown and known as.
Yes.
A and D are 2 different parcels of leasehold property with different registered title numbers. Do we know what they are respectively?
Yes. You'd be forgiven for overlooking the odd reference that there might be in this bundle to something called a car park lease.
Right.
But there was a separate lease in similar terms to the common parts lease of a car park, which was part of the same overall physical structure. And there was a separate deed of covenant that went with that lease as between NTRML and the tenant of that lease.
We're not concerned with.
And that's not, this court isn't concerned that it's not the subject of these proceedings.
And is that little a?
Yes, that's A.
And is there a corresponding deed of maintenance then?
Yes, there is.
So is that B? Must be B. Car park.
Yes, that would be B because it refers to the car park management company. And then C is the deed of maintenance that goes with the common parts lease, and D is the registered title number for the common parts lease.
That explains my next question, which is when B says the property situated at a deed of maintenance, that seems quite an odd expression, but we're not concerned with that. That's car park property.
That's car park property indeed.
What we're concerned with is D, the leasehold property, and C, the deed of maintenance, which is disclaimed as an onerous contract, I take it.
That's right.
And the reason it's an onerous contract is because it contains a covenant by the CP lessee with Crosby initially,
Yes.
to comply with the covenants in the
Indeed.
CP lease.
Yes.
Yes. And so the effect of vesting this is that the deed of maintenance becomes vested in the receiver. Is that right?
Well, that's clearly what was intended at the time, and that's what they believed. But as I think was explained this morning, a query was raised about that during the course of negotiations for a sale. And the buyer's solicitors suggested that the deed of maintenance wasn't capable of binding successors. And therefore, it must follow from that this provision in the vesting order had no effect because it had ceased to bind. And it was for that reason, again, rightly or wrongly, I don't think anything turns on it, that the parties entered into a novation.
Do we have the novation?
Yes, we do. It is...
So is that with the receivers then?
Yes, it was. It's tab 8 in the supplemental bundle. Perhaps it follows on from the vesting order.
Is this the second novation then? Because there was one in favour of NTRML, or is this? Am I confused?
This is the only innovation. This was the one in favour of NTRML. So until this document was executed, the parties had been proceeding on the basis that the deed of maintenance, as it's called, at tab 1 of this bundle, remained in effect.
But with Crosby?
Well, yes.
Okay.
And there's an argument that I think my Lord Justice Nugee alluded to this morning, that it might have bound and become enforceable by successors under Section 12 of the Landlord and Tenant Covenants Act.
Oh.
Now, it wasn't my suggestion, it was Mr Justice.
Forgive me, my Lord. That's not a point that has ever arisen.
Okay, but that's as between Crosby and NTRML, is it?
Well, it would also be as
And-
between a
and-
successor to Crosby
Okay.
and a successor to the original common parts lessee. So as success,
see.
the successors to both parties, the deeds of maintenance,
Yeah.
could, if that argument holds good, enforce it as between themselves. The reason I'm hesitant about it is it's not a point that's been raised before, and so I haven't had a chance to look at it. And the two parties to the deed of maintenance were not in any sort of landlord and tenant relationship with each other.
No,
And so,
but what Mr Dutton said was that the Landlord and Tenant Covenants Act picks up a service charge type obligations, even if the person who's obliged to provide the services and entitled to enforce the service charge doesn't have an interest in the demised premises, so isn't in a landlord-tenant relationship. It goes with the tenancy, which makes a great deal of sense, because you do sometimes see covenants by management companies
Indeed.
to provide services and rights of management companies to collect service charges, even though they don't have any leasehold interest in the structure.
Indeed. The reason for my hesitation is that applies where the management company is party to the lease.
I see. Whereas this is a separate document.
If one draws it diagrammatically, there's the freehold at the top, and then the common parts lease comes down one line, the residential head lease goes down another line, and they're only connected contractually by this deed of covenant or the original deed of maintenance.
It would seem very odd if the application of the Act turned on whether the deed of covenant was in the same document or a different document.
It would.
But I entirely understand you haven't looked at the point.
Yes.
And I think it's probably common ground. We don't have to concern ourselves.
Yes.
My lord, I don't think that is going to be common
Well,
ground.
maybe it isn't common
Well,
ground.
When we ask ourselves, is the acquisition of the common parts lease necessary or whatever, the only thing should we say, the gold kernel which the receivers were wishing to achieve was the ability to enforce the service charge obligations in the maintenance deed.
Yes.
And so the rationale for getting the common parts lease was so that they would get with it the benefit of the maintenance deed. And so I'm afraid this is potentially rather an important point.
Okay, but that does go round, possibly goes round in a circle, because the key provision in the maintenance deed is an obligation to perform the covenants in the
indeed.
CP lease.
And if the CP lease has been disclaimed, then that obligation falls away. Or at putting it its lowest, that is certainly a reasonable view for somebody in the receiver's position to take, which would therefore engage the provision in the powers that we were looking at, that Mr Dutton refers to. So does that address your lordship's point about the deed of covenant? I will, in case, I have to say, our position at the moment is that it isn't of relevance to the issues that the court has to decide. It certainly wouldn't accept it's a golden kernel. But in case it is, I will open up the Covenants Act and have a look at that, because it's a somewhat unusual application of Section 12, if I may say so.
Yes, but what I understood Mr Dutton to be saying just now about the golden kernel is obtaining the lease by itself is not of any particular value. I mean, it's just an obligation. It's the right to recover the cost of complying with the services from Crosby or its successor, NTRML, which is what you really want to get at. Is that not right?
Yes.
That's not in the lease. It's not in the CP
No.
lease. It's in the deed of covenant. So it is in that respect that the reason you want a CP lease is so you can enforce the obligation to pay for the works in the deed of maintenance. So it's the deed of maintenance which is what you really want to get at.
Yes.
And that's what I understood him to be saying
Yes.
now. And that seems to me to be not only right, but I think not disputed.
No, I can't dispute that. Of course, it's that obligation that is key to the receivers in the position they found themselves in. Whether the original deed of maintenance, once revived by the vesting order, was capable of binding and being enforced by the receivers and NTRML, as opposed to the original parties to it, we would say is a subsidiary question. In practice,
they put in place a novation anyway.
They put in place a novation, and that novation, you'll see from the date of it, was January 2015, which was...
it's almost a couple of years later.
Indeed, the vesting was in 2013, and they had been proceeding during those intervening months on the basis that it did apply. And it was only, as I've said, when the question was raised by a purchaser that they realised there might be a legal problem. And so they put in place the novation.
So, though the members of the Constitution like me who are a bit slower, can you now summarise for us why, in the light of this discussion about the importance of the deed of maintenance, you say that the CP lease was required or convenient?
Well, it's the answer's a very short one, my lord. It is an essential part of that jigsaw. Without the CP lease, as my lady indicated, the deed of maintenance couldn't function, or at least the obligation which the receivers required to enforce under it couldn't be enforced, because the obligation was to pay a service charge in respect of the performance of the services under the CP lease.
So in other words, no recovery from the residents, effectively, unless you've got the CP lease in place.
Indeed.
All right, thank you.
So unless there's anything else that my lords and my lady wish me to address on ground one, I'll move on to the second issue, which is specific performance. And just to orientate ourselves, this arises if my learned friend succeeds on ground one, so that the judge's reasoning about the receivers being Alma's agents and being entitled to an indemnity from Alma for costs incurred in performing their obligations under the lease doesn't apply. And the question that then arises is whether, in the absence of those strands of reasoning, the judge's conclusion that specific performance should be refused should nevertheless be upheld on the basis of the judge's reasoning that Alma should be left to other remedies. Now, on that, we do say that the way the judge articulated his conclusions on specific performance, he made clear that he considered that the alternative remedy point in itself was sufficient. Now, I'll go to that paragraph in the judgment in a moment, but really all this goes to is the test that the court has to apply. Is the court reviewing an exercise of the judge's discretion, or is the court exercising that discretion afresh? And all of the arguments that the court's heard...
You say that's the only thing it goes to, but that's kind of important.
Well, indeed. But it's only a short point, but the reason I say it is that when one has a look at paragraph 124 of the judgment, it's page 75 in the core bundle. The second sentence of paragraph 124, we say, stands on its own feet. And the judge made clear there his view that the appropriate remedy, if the claimant doesn't require the CP lease and the deed of covenant to be transferred to it, is for the claimant to exercise the rights that it has to carry out the works, or alternatively to consent to the CP lease being assigned to NTRML so that NTRML may do so. So it's only a minor point, but we say that the judge in that sentence concluded that the alternative remedy that's open to Alma is in itself sufficient to defeat the specific performance argument. The substantive question is whether that is right. And in relation to that, I'll deal first of all with the principles and respond to the way in which Mr Dutton urges the court to consider the exercise of discretion in relation to specific performance, and secondly with the application of those principles to the rather unusual facts that we have here. And the facts we say are still unusual given this leasehold structure, even if one strips out of them, as one must if this issue arises, the receivership point. So in terms of the principles, historically, I might have been able to stand here and make the submission that it is simply not open to the court to make an order for specific performance against the receivers as tenants, however appropriate the court might think specific performance is, as a matter of principle. But then, as noted by the Deputy Judge in Tokenhold, even that 30-odd years ago was questionable. But a rigid rule of that sort is clearly incompatible with the modern approach to the exercise of the court's discretion. And so there's no dispute on this side that the Deputy Judge in Tokenhold was right to consider that it is open to the court in principle to make an order for specific performance in respect of a tenant's repairing obligation. In outline, what we say is that the approach to that question advocated by the Deputy Judge in Tokenhold was the right approach, and the judge was right to apply it in this case. And doing so, applying that approach, leads to the conclusion that specific performance should be refused on the sole ground that Alma has alternative remedies which it ought to pursue. When I've gone through the authorities, I'll come on to look at what those alternative remedies comprise and how they operate. Before we get to Tokenhold, that approach to specific performance is consistent, we say, with the reasoning of Lord Hoffman in Co-op and Argyll, which is a case that the appellants cite in their skeleton argument. I don't think Your Lordship was taken to it this morning, but I would invite the court to go to Co-op and Argyll. It is behind tab 8 in the authorities bundle. The court's no doubt familiar with the factual scenario that was in issue here. It was about specific performance of an obligation to keep open a business, which is rather different to the one we're dealing with here. But the statement of principle by Lord Hoffman in the House of Lords is of rather more general application. And if I could take the court to page 127 in the authorities bundle, please. And at letter F, in very general terms, Lord Hoffman said this. He said that a decree of specific performance is, of course, a discretionary remedy, and the question for your lordships is whether the Court of Appeal was entitled to set aside the exercise of the judge's discretion. There are well-established principles which govern the exercise of the discretion, But these, like all principles, equitable principles, are flexible and adaptable to achieve the ends of equity. And then he says that much depends on the facts of the particular case. And then on to page 129, under the heading, The Settled Practice, again next to letter F. He said this: specific performance is traditionally regarded in English law as an exceptional remedy, as opposed to the common law damages to which a successful plaintiff is entitled as of right. There may have been some element of later rationalisation of an untidier history, but by the 19th century it was orthodox doctrine that the power to decree specific performance was part of the discretionary jurisdiction of the Court of Chancery to do justice in cases in which the remedies available at common law were inadequate. This is the basis of the general principle that specific performance will not be ordered when damages are an adequate remedy. And we would respectfully emphasise the exceptionality of the remedy, which is stressed by Lord Hoffman and runs through the various other authorities that are before the court. And then, before I leave this authority, at page 134, below letter B, in the third line of that paragraph, he effectively sums up in this way: of course, the grant or refusal of specific performance remains a matter for the judge's discretion. There are no binding rules, but this does not mean that there cannot be settled principles, founded upon practical considerations of the kind which I have discussed, which do not have to be re-examined in every case, but which the courts will apply in all but exceptional circumstances. So the remedy is not a remedy that is available as a matter of course. It is exceptional. Here, in the circumstances of this case, it's although the authorities speak of damages as an alternative remedy, we don't, of course, advocate a remedy for Alma in damages. We point, as did the judge, to alternative common law remedies that Alma had under the terms of the lease, namely what have been loosely described as the step-in rights, with the benefit of a claim in debt in respect of costs that are incurred, and it suggests that nothing turns on the distinction between damages and the exercise of those as alternative remedies. Now, before I come to token hold, I would also take the court to a more recent statement of principle, which reiterates the importance of there being no alternative remedy in the judgment of the Supreme Court in Cavendish and Macdessie, which is behind tab 3 in the authorities bundle. And
Is there some reason why the authorities in this bundle are in random order?
I think, I didn't put it together myself, I think they're in reverse chronological order. I don't try to suggest that is the best way of ordering an authorities bundle, but that is the order, my lord.
Okay.
Tab 3 is Cavendish and Macdessie. Now, this, again, I'm sure the court will be familiar with it. It is a case that is all about the rule against penalties. And we've spared the court the full 150-odd pages of the judgment on that subject. The circumstances in which equity will intervene by making an order for specific performance were considered by Lord Neuberger and Lord Sumption, who gave a joint judgment in the context of their consideration of the principles which ought to apply to determine when a payment clause is or isn't an unenforceable penalty. And if you go to page 57 in the numbering in the authorities bundle, at paragraph 29, you can see that the context for paragraph 30, which I'm going to invite the court to consider and apply, which is that the court's looking at the principle that the law will not make a remedy available where the impact of that remedy on the defaulter exceeds the legitimate interest of the defaulting party, and then various examples of that principle were explored by Lords Neuberger and Sumption, and at paragraph 30, they address specific performance. And what they say is that the attitude of the courts, reflecting that of the Court of Chancery, is that specific performance of contractual obligations should ordinarily be refused where damages would be an adequate remedy. This is because the minimum condition for an order of specific performance is that the innocent party should have a legitimate interest extending beyond pecuniary compensation for the breach. I think this was described by my learned friend in his oral submissions as a soundbite. I would respectfully suggest that this is a considered statement of principle by the Supreme Court, and would invite the court to follow it, even if it is strictly obiter. And it's worth pointing out, given since my learned friend relied on the general explanation in Snell behind tab 16, that this as a statement of principle is also endorsed by the authors of that text at page 217 in the authorities bundle. In the second of the 3 paragraphs on that page. And for reasons that I'll come to, we say that Alma simply doesn't get over this minimum condition. And before I eventually get to the substantive points that are advanced against me, I ought to come finally to token hold, which is behind tab 7. And the court was taken to the relevant passages by my learned friend, and I'm not going to go through the whole case again. But essentially, we rely on the passages on page 73, which were noted by Mr. Dutton. Although I should point out, I'm sure that this didn't escape the court's attention, but when my learned friend was reading out the second paragraph that begins subject to the overriding need to avoid injustice, he did stop reading at the colon in the 5th line. And of course, what we rely on is the direct statement by the deputy judge in this case that a relevant and important factor, as he describes it, is that the landlord may not have a right of access to the property to effect necessary repairs, since in the absence of contrary agreement, a landlord has no right to enter the premises and the condition of the premises may be deteriorating. And that, as you were shown this morning, was in fact what happened on the facts of this case. And that was, as we see in the paragraph that begins at the end of page 73 and then over onto page 74, was the reason why the deputy judge in that case decided to take what is the exceptional course of making an order for specific performance against the tenant. The property was in a dire condition. Local authority enforcement notices had been served on the landlord, and the only way, given the existence of the lease, which reserved no rights of entry to the landlord, that the landlord could have these important works carried out, was to get an order for specific performance. And we would respectfully commend to this court, this of course being a first instance decision, that the way in which the deputy judge summarises the position at the very bottom of page 73 and the top of page 74, where there is a claim for specific performance by a landlord against a tenant. He says it follows, not only is there a need for great caution in granting the remedy against a tenant, but also that it would be a rare case in which the remedy of specific performance will be the appropriate one. In the case of commercial leases, the landlord will normally have the right to forfeit or to enter and do the repairs at the expense of the tenant. And in residential leases, the landlord will normally have the right to forfeit in appropriate cases.
So he's expressly contemplating step-in rights as being a reason for not granting specific performance.
Indeed. Now, I accept the point that's made against me that can't be applied as a sort of high-level principle, as it were, that the very existence of any sort of step-in right, however difficult it is to exercise, can in and of itself bar specific performance. But what he is saying is that it will be exceptional to grant the remedy in favour of a landlord against a tenant. And where there are inter alia step-in rights, that is likely to be a very important consideration. And we say that applies in this case, and that is what the judge accepted in that part of his judgment. So in terms of alternative remedies, it's quite right. We don't rely on forfeiture as a realistic option in the circumstances of this case as being open to Alma in place of applying for specific performance. It could be in other cases where there is a strong likelihood that the tenant would apply for relief, and relief would only be granted on terms that the works are carried out, but that's not this case. But we don't need to rely on forfeiture as an alternative remedy because of the existence of step-in rights. And step-in rights might put the landlord to expense. It might involve risk to the landlord of the tenant not reimbursing the costs, but they are pecuniary interests. And going back to Lord Neuberger's formulation in Cavendish, the landlord in most, I wouldn't say all, but in most cases, and certainly here, has a legitimate interest in ensuring that the works are carried out, but that interest can be served by relying on the step-in rights. What specific performance is not intended as a remedy to achieve is to protect the landlord's pecuniary interest, which can be protected by the debt action which follows the exercise of the right of entry under the lease. So I turn now to look at the rights that were and are available to Alma in this case. And what is said in relation to that is that these rights involve all sorts of risks, such as to make this the sort of exceptional case where, notwithstanding the existence of those rights in the contractual scheme, specific performance ought nevertheless to be granted. Now, we don't accept that the risks, as they are put, in relation to the exercise of the rights and in relation to recovery of the cost afterwards, are anything out of the ordinary in relation to step-in rights in commercial leases. In fact, when we come to look at the terms of the step-in rights, we say that Alma is in a better position in exercising those than many other commercial landlords. So, can I invite the court please to take up the supplemental bundle and turn to tab 3, please, which is the common parts lease. And I'm going to begin not with clause 6.7, which is the subject of my learned friend submissions, but clause 6.2 on page 87. And this is where my point about the plans comes in. So clause 6.2 provides that if the company, that's the tenant, defaults in the performance of any of the covenants contained in this lease for and relating to the repair of the premises, with a capital P, the landlord may, but without prejudice to the right of re-entry, enter upon the premises and repair the same at the expense of the company in accordance with the covenants and provisions of this lease, and the expenses of such repairs shall be repaid by the company to the landlord on demand. Now, so far as concerns this claim for specific performance, the claim in relation to works required to the roof will fall within clause 6.2, because for the reasons I've outlined, the roof is demised. And in terms of precondition, once there is default in the repair of the premises, the landlord has the right to enter and carry out the repairs. There are no preconditions requiring schedules of works to be given, schedules of defects. There's no precondition requiring the landlord to give the tenant an opportunity to do the work first if the landlord discovers that it hasn't been done.
Doesn't need to give any notice.
Well, I would accept that it must be implied that some notice is required, but I'm not going to suggest a period of notice, but it is a minimal requirement, if I can put it that way, because we're not dealing with entry onto someone's commercial premises or their dwelling. This is the fabric of the building that we're dealing with. So notice is only required to the common parts lessee to alert the common parts lessee that somebody else, i.e. the landlord, is going to carry out works to the fabric of the building that is demised, because this only applies to the premises as demised.
You don't need leave under the 38 Act to exercise a right of this. I can't remember how the 1938 Act works.
The 1938 Act applies to exercising rights of forfeiture and claims for damages.
It doesn't apply to step-in rights.
Well, I can hear my learned friend taking issue with what I'm about to say before I've said it, but
all I say is, I'm sorry, I hadn't appreciated this point was being raised. I do apologise. We may need to refer to additional authority on this, because the CDAC case and Colchester Estates and case like that are basically if the right under 6.2 is properly to be regarded as giving rise to an action on a debt, then the 1938 Act will not apply. If, however, clause 6.2 is interpreted as giving the right to liquidated damages, then the effect of the 1938 Act is that in order to bring that claim, the landlord would need to serve a section 146 notice, which complies with the 1938 Act, would have to wait, giving the tenant the opportunity to carry out the works, and if the tenant gives a counter notice in relation to that, the landlord would then need to apply for the court's consent before bringing a claim for the debt for the money under 6.2. But it does depend on the proper categorisation of the cause of action that arises under 6.2.
Seems a bit strange having regard to the wide view of debt taken in Jarvis and Harris.
Well, Jarvis and Harris is a case which is in the same line of authority, but that was a case where it was clear on the language of the covenant that it was a cause of action in debt. But that doesn't, so if you're satisfied on the language of 6.2, that when it says it will be repaid by the company to the landlord, if you're satisfied that that is an action on debt rather than an action for damages, then my learned friend, what he says is right. But the problem is you do have to categorise the nature of the cause of action, because if it's a claim for damages, then the Act applies, and that's what the earlier cases address. And so it may be sensible to look at those cases to see how they categorise the nature of the right.
And can you remind me, which leases does the 1938 Act apply?
It applies to leases granted for terms of 7 years or longer, where there is 3 or more years left unexpired.
Of any nature, residential, commercial?
Of any nature. As I say, I do apologise, because if I'd realised this point was being taken, I'd have made sure that the bundle of authorities contained some extra ones.
Thank you.
Well, I don't criticise my learned friend for raising the point as he does. The judge dealt with the alternative remedy point on the basis of clauses 6.2 and clause 6.7. There was no suggestion below, and there's been no suggestion until now, that clause 6.2, like clause 6.7, is not properly so called a Jervis and Harris clause, and therefore one to which the 1938 Act doesn't apply. So I'm not armed at the moment to deal with the authorities my learned friend mentions.
We're both taken by surprise.
Clause.
Oh, I'm sorry I raised it.
I mean, what I would say, just by way of immediate response to the point, is that clause 6.2 provides in the penultimate line that once the landlord has carried out these repairs, the expenses are to be repaid on demand. The expenses of carrying out those repairs are to be repaid on demand. Clause 6.7 over the page that the court was taken to this morning provides that the landlord may, in the penultimate line, recover the cost reasonably incurred from the company. In substance, we say there is no difference in terms of categorization between those two formulations. They both clearly, we say, amount to debts that are therefore outside the scope of the 1938 Act.
Thank you.
So clause 6.2 has minimal preconditions, and as I said, I accept there would be an implied condition of some notice. Clause 6.7 that was looked at this morning, again, has a requirement of 28 days notice to the company to perform any obligations that haven't been performed. And then if the company fails to do so, the landlord can go in and fulfill those obligations and recover the cost as provided there. Even that additional requirement in clause 6.7 doesn't come close to the usual sort of precondition that the text in Dowding and Reynolds addresses that my learned friend took the court to this morning. Just by way of example of a more conventional right of entry, we can find that example in the sample lease of one of the flats that's in the bundle, behind tab 4, and at page 112, clause 7.5 provide this is a tenant's covenant to permit the landlord and the company's the residence management company, which wasn't originally the tenant under the residential head lease, and persons authorised by the landlord or the company at reasonable times on giving reasonable notice to enter and examine the state of repair and condition and commence to repair and make good all defects for which the tenant is responsible and of which notice in writing has been given. So it's not the most straightforward of drafting, but that is a rather more standard provision for giving notice of defects following an entry for inspection. And that's the sort of provision that can give rise to the type of dispute that was highlighted in the text in Dowding and Reynolds. As I alluded to a few moments ago, there is some justification for requiring this higher degree of protection in the lease of the flat than in the common parts lease, because this involves intrusion into someone's living space. In an ordinary commercial lease, a right of entry will involve intrusion into the premises that are demised. The common parts lease is peculiar in that sense because it demises the structure or part of the structure and fabric of the building, and the repairing obligation applies to other parts of the structure and fabric of the building. So under clause 6.7, going back to the common parts lease, that the landlord, it's not actually a right of entry as such, because the landlord doesn't need to enter, because the parts of the premises that are not demised remain within the landlord's possession. So the entry bit of it isn't even required. It's simply giving notice to the tenant to perform an obligation in respect of parts of the building that are retained by the landlord. So the legitimate interest, as we would accept, of the landlord in getting the building repaired is capable of being achieved straightforwardly, we say, by the exercise of these step-in rights. It was said by Mr. Dutton this morning that exercising these rights is time-consuming and will involve litigation and risk. Well, I've already addressed that, and we don't accept that as a proposition, but even if there is some risk that could lead to litigation, it's no more risky, we would suggest, than taking the alternative course of going to court and seeking specific performance. And there's a further point here that even where it is necessary, we say it's not necessary under these provisions, but even where it is necessary under a step-in right to specify the works, and there's a potential trap for a landlord who doesn't specify everything that's required and then is precluded by the tenant or by injunction, if necessary, from carrying out other repairs that haven't been specified. A very similar risk applies when a landlord claims specific performance, because it's trite law that in order to get specific performance, a claimant, or specific performance in respect of carrying out of works, a claimant must specify the works that are to be the subject of the order, and they must be specified sufficiently to enable the defendant who's being ordered to carry them out to understand what has to be done. And if it is...
You can't just get an order that the covenant to repair be specifically performed.
No, you can't. I mean, the point is addressed in token hold.
Yes.
And I can give your lordship the reference.
It's the same principle of injunctions.
Indeed.
Defendant needs to know what it is they have to do.
Yes, exactly. I mean, that's the principle, and it was referred to. It's at the top of page 115, just for your reference, in the authorities bundle, where the deputy judge in token hold said that the problems of defining the work and the need for supervision can be overcome by ensuring that there is sufficient definition of what has to be done in order to comply with the order of the court. I mean, maybe I was going a bit too far and I said it's trite, but it's certainly recognised by those who are in the business of making applications of that sort that the works that are required to be carried out need to be specified clearly and precisely, so that the party bound by the order knows what to do in order to comply. And that is another emanation of the same problem that Mr. Dutton says can arise in relation to rights of entry. So if the court is balancing a landlord's exercise of a right of entry on the one hand as against going for specific performance and compelling the tenant to carry out the works, that is not, we would say, a strong factor. But in any event, as we've said, that doesn't even arise under clauses 6.2 and 6.7. So that's the first collection of risks that Mr. Dutton relies on, risks associated with invoking the specific rights.
Yes, just before you moved on, by way of a footnote to our previous discussion, I've now remembered where Jarvis and Harris was mentioned, and it's in your first skeleton argument, paragraph 52, page 190 in the core bundle, where you make the point, albeit in relation to clause 6.7 rather than 6.2, that shows that the claim would be in debt rather than damages.
Yes, I take your lordship's point.
So you did mention it, you just didn't say in terms the same applies to 6.2.
No, I take the point, and as I've said, I don't object to my learned friend making a point about it if he thinks that's appropriate.
Yeah, thank you.
The second category of risk that the appellant relies on to say that specific performance is appropriate as opposed to relying on the rights of entry is the risk of not being paid the costs that are incurred in exercising the right of entry. Now, as I've said, contractually, the landlord's entitled to recover the cost as a debt. It doesn't sound that that is disputed in relation to clause 6.7. It may be disputed in relation to clause 6.2. If there is that distinction between the two clauses, it would be open, I would submit, to the landlord to rely exclusively on clause 6.7. Because 6.7 applies generally to the company failing to carry out any obligations under the lease. So there's an additional precondition to exercising that right that doesn't arise under clause 6.2, namely giving notice and an opportunity to the tenant to perform. But if it is right that there is this significant difference in effect between exercising the two rights, it is open to the landlord to rely exclusively on clause 6.7. So we say that on any reckoning that the claim is a debt claim. And as I've already said, risks that arise in relation to non-payment are risks in relation to the pecuniary interest of the sort which equity shouldn't be protecting by an order for specific performance. The concern here of the landlord is not about getting the works done. The concern is about whether or not the landlord's going to be paid for the works. My second point in relation to the risk of not getting paid is that the focus should be on the debt owed by the tenant, that is, here, the receivers.
Sorry to interrupt you, but can I just go back to something you said earlier? Because what you said a moment ago seems to imply that it would be good enough for your client's case to rely just upon clause 6.2. But that's not right, is it? Because 6.2 covers the roof, but you need 6.7 for the main structure and facades of the building, don't you?
I'm sorry, my lord. I'm sure it's my fault. I'm probably galloping. I thought I said 6.7 can be relied on to the exclusion of 6.2. So 6.2 is a specific right that applies to the premises.
Yes, and that includes...
That includes the roof. But 6.7 applies wherever the company fails to carry out any of its obligations under the lease. That includes obligations in relation to the roof.
Yeah, but sorry, we're at cross purposes here. My understanding, and correct me if I've misunderstood, because I may have done, is that while 6.2 covers the roof, it does not cover the main structure of the building.
That's right.
Right, including the facades.
Yes.
So 6.2 doesn't help you insofar as the works are required in relation to the facades.
No.
Right. So you need both.
Well, we say we can rely...
Or to put it another way, you can rely just on 6.7.
Yes.
But in that hypothetical scenario, your arguments about 6.2 wouldn't help you, because you just, on that hypothesis, you'd only be relying on 6.7.
Indeed. The only reason we would have for relying exclusively on 6.7 is if my learned friend's point that he's just made about 6.2 sounding in damages is a good one.
Yeah, all right. But I'm sorry if I'm labouring the obvious. But the point of my intervention is to establish, and I think you're agreeing with this, is that what you can't do, hypothetically, is to rely upon just 6.2
Indeed.
And not 6.7.
Absolutely. Forgive me if I wasn't making that clear. That's the point I make.
Yeah. Understood.
So, in terms of the risk of not getting paid, we say that the focus should be on the debt that is owed by the tenant. There's no evidence that the receivers wouldn't be good for the money. There's no evidence that the receivers would refuse to pay, and that Alma would need to somehow look to NTRML for recovery. And I think that there was a reference from the bench this morning to paragraph 124 of the judgment on page 75, at the very bottom of page 75, where the judge said that there was no suggestion at trial that the claimant, through the CPC group, which is its controlling entity, was unable to pay for the works to be done, or that the defendants could not pay damages. So that, we say, amounts to a finding that in the circumstances of this case, the sort of bother that my learned friend hypothesises about would not arise. There would be a debt claim in respect of the costs incurred, and the receivers would pay that debt.
Yes, it may be that the references to bother go beyond the purely financial.
They do, and all of the points I'm addressing now go to bother, but in relation to that particular bit of bother that he's concerned about, we say that just doesn't arise on the facts.
There's also a suggestion in Snell that even if somebody is liable to pay damages and there is doubt as to whether they can pay, that's not a relevant consideration.
Well, indeed, that was another point I was going to make, my lord. Is
that right?
Well,
I mean, that seems... I had always thought that one of the questions whether damages was an adequate remedy or not was whether you'd actually get the damages, how difficult they were to quantify, and whether you'd actually get them. But it seems that...
In the interim injunction context, that is plainly so.
Yes, exactly.
Well, the way I was going to deal with it, even if this is thought to be something of a fudge, is that it just doesn't arise on the facts here for the reasons I've explained.
Yeah. If it's not a point you're relying on, we won't have to grapple with it.
No, I'm not inviting the court to grapple with it because it's entirely hypothetical on the facts here. The next point is that Alma has, as the court has seen, a liability under the common parts lease to contribute approximately 50% of the cost of the works. So all of these points about recouping the cost apply only to the balance that Alma doesn't have to put in itself. Now, it's said by the appellant that that is irrelevant. There is a cost, there is a balance which Alma has to recoup. But the judge didn't think it was irrelevant, and in my submission it isn't. It is another relevant factor that counts in favour of the landlord exercising these alternative remedies. And then finally, under this head of argument, my learned friend relied on concern. This must be concern of Alma's, that the receivers would not be able to recoup the full debt that they have incurred to Alma from NTRML because of the application of the Landlord and Tenant Act 1985. Now, there's quite a lot that one could say about the application of the 1985 Act. It is far from straightforward in the circumstances of this case. I would suggest that it's not entirely clear that under that Act, the contribution that NTRML is obliged to make to the receivers would be subject to those restrictions. And I'll address the terms of the Act in a moment. But in general terms, we say that this is just not of consequence to Alma's position. Alma's debt claim is against the receivers. If the receivers face a risk of being out of pocket in respect of their claim against NTRML, that is not a factor that goes to Alma's consideration of whether to exercise the right of entry, or more pertinently, the court's balancing of the interests, whether it ought to leave Alma to exercising the right of entry as opposed to making an order for specific performance. That is simply an irrelevant consideration so far as this exercise of discretion is concerned. So far as the application of the 1985 Act is concerned, if the works are carried out by the common parts lessee, so the receivers while they hold the common parts lease, it is questionable, and I don't put it any higher than that because it's not we would say it's not an issue that this court ought to resolve. It's an issue that concerns many others who aren't before the court. But it is questionable whether NTRML's obligation to pay Alma is subject to those limits. The relevant parts of the 1985 Act are in the authorities bundle. It's behind tab 18.
Just before we get into the detail, doesn't seem to be anything in the judgment about this. Is this because this wasn't argued below?
No, this wasn't argued.
Right, thank you.
So on page 222, under section 20 of the 1985 Act, and I'm looking at subsection 1 here, the relevant contributions of tenants are limited in relation to qualifying works or qualifying long-term agreements, we don't need to worry about the latter, are limited in accordance with subsections below. And in effect, we don't need to go into subsection 6 or 7. In effect, if either little a, the consultation requirements have not been complied with, or little b, dispensed with by the first tier tribunal, then the contribution of each tenant is limited to £250. And the argument by my learned friend must be that if the consultation requirements haven't been complied with in relation to works that the common parts lessee carries out, then NTRML doesn't have to pay any more than £250 unless there's been a dispensation order by the first tier tribunal. The question of whether this applies depends on whether it is a relevant contribution, and we're told by subsection 2 that a relevant contribution in relation to a tenant and any works or agreement is the amount which he may be required under the terms of his lease to contribute by the payment of service charges to relevant costs incurred on carrying out the works or under the agreement. Now, we haven't, I'm afraid we don't have the definitions in the bundle, and I can provide them to the court. We don't have the definitions of relevant costs or service charges which are relevant to this point. Oh, I'm being told from behind, I can hand them up if that would assist.
Thank you.
Haven't you got a simpler point? Does an NTMRL, even if it's a tenant, is not required to contribute under the terms of its lease? It's required to contribute under the terms of the deed of maintenance.
Your lordship has got to where I will be ending up. It arises out of the definition of service charge, which is an amount payable for services under the terms of a lease. And NTRML, it's arguable, and I don't put it higher than that, it is arguable that NTRML doesn't pay it.
Yeah, but it's not even, you don't even have to go to the definition, it's in subsection
Well, it's there as well, and but that derives from the definition of service charges. But that is the point. So it may be that this doesn't apply. Now, I say this somewhat hesitantly for two reasons. First of all, there's a good deal of authority, mainly up at tribunal, about the interpretation of these provisions in all sorts of weird and wonderful scenarios, albeit none of which remotely mirror the one we're looking at. And so the question is not an entirely straightforward one, but more importantly, we would say it's not a question that this court needs to decide or ought to decide, because the parties who will ultimately be affected by that decision are NTRML and the residential under lessees. So the first scenario then, where it is the receivers complying with the tenant's covenants in the lease and carrying out the works, it is questionable, we say, whether the limits apply. We look then at the scenario where Alma exercises its step-in rights. We would accept that the debt that becomes due from the receivers to Alma is not a relevant contribution, because it's not a contribution by the payment of service charges. And that is the case because the paying party, the common parts lessee, is not the tenant of a dwelling. We get that from the definition of service charge in section 18. Following provisions of this Act, service charge means an amount payable by a tenant of a dwelling as part of or in addition to the rent. So far as Alma is concerned, and I reiterate the point I've already made a number of times, that Alma's concern, and therefore the court's concern, is only whether the receivers will be good for the debt. Alma doesn't need to worry in respect of that claim about the receivers holding up section 20 and asserting a defence to the debt that arises under the step-in provisions. And then, if, notwithstanding what I've said, it's considered relevant to address the position of the receivers as against NTRML, well, the position is the same as before. It's then something of a grey area as to whether the receivers, in passing on that debt to NTRML, are subject to section 20. So in relation to NTRML's debt to the receivers, the judge again made a specific finding that NTRML will pay its share. And it's important that we have in mind that we are dealing here with a claim for specific performance in respect of this particular schedule of works that are required to the building. We're not dealing at this point, as opposed to in relation to the counterclaim, with the position of NTRML as against the receivers for the duration of the lease. This is just in relation to the costs of these works. And the judge made a specific finding at paragraph 93 on page 68 in the core bundle. In the last three lines of paragraph 93, he said, on the basis of the evidence that I heard, it is clear that NTRML will not refuse to contribute its share of the cost of the works, whether they are carried out by the claimant or the defendants or by it, that is NTRML. And really, our submission is that that finding makes all issues that are raised by the appellant about the ability or the willingness or otherwise of NTRML to pay irrelevant, because that finding isn't challenged, and that disposes factually of all of those reasons that are advanced for refusing, for granting, I should say, specific performance. Now, finally, in relation to specific performance, that deals with what have been described as the risks and the bother associated with the exercise of step-in rights. And finally, my learned friend relied on what he described as the composite transaction, the overall contractual structure, which he says is another reason why Alma should not be left to rely on its step-in rights and specific performance ought to be granted. Now, of course, that there is in this structure a web of contractual obligations. The receivers owe obligations to carry out these works to Alma. Alma owes an equivalent obligation to NTRML, so yes, in theory, NTRML could seek to enforce that obligation, but as was indicated when that point was being advanced, factually, that is not what has happened, and there is no indication that that will happen. Exactly the same point in relation to the obligation that the receivers owe to NTRML under the Deed of Covenant. NTRML could seek to enforce that directly against the receivers, but it hasn't. There's no reason why we say this should affect the question of whether it's appropriate to require Alma to rely on its step-in rights. Those step-in rights in the common parts lease are also an important part of the overall contractual structure. So if the obligations aren't performed, Alma has the right that was bargained for by the original freeholder to enter and carry out the works. And there's no reason advanced, no good reason advanced in this case, we say, why the principles that were explained by the deputy judge in Tokenhold shouldn't be applied equally here, and the landlord left to rely on those step-in rights. Going back to where I started on specific performance, that is precisely how the judge analysed matters in paragraphs 92 to 95 of his judgment. And our submission is that that reasoning by the judge holds good on its own, independently of the reasons that the judge relied on in relation to the receiver's status as receivers, and as an exercise of discretion, this court shouldn't interfere with it, or putting it the way my learned friend does. If this court is exercising the discretion afresh without regard to the receivers having the status of receivers, then the alternative remedy ground, as it's described by the judge, is sufficient to for the court to refuse specific performance. Now that, my lords, my ladies, is all I have to say on specific performance. I was intending to go on from there to what my learned friend describes as his issue 4, because I'm in territory where I have succeeded, where I have failed on ground 1, and I am therefore not acting, or I wasn't acting, under the powers as a receiver, and that is the same territory that applies for issue 4 and my alternative argument on the counterclaim. If and I appreciate that the court hasn't heard argument from my learned friend on issue 4 yet. If the court would prefer me to deal with issue 3 first, I can do that.
I think we're content with you arguing it in whatever way you think best.
Thank you. So, again, just to navigate where we are with issue 4. If Alma is successful on ground 1, and therefore the receivers didn't have the power as receivers to obtain a vesting of the lease, the arguments that the judge advanced for dismissing the counterclaim don't apply. And in this scenario, we say, unlike specific performance, but in this scenario, the judge gave alternative reasons on the express basis that these reasons would apply if he were reversed on the issue of the indemnity, which ultimately led him to conclude that the Arga condition was unreasonable, and therefore that consent to the assignment to NTRML was unreasonably withheld. And the judge's alternative reasons on this scenario are set out at paragraphs 187 to 193 on pages 90 to 91 of the judgment. And as I've said in paragraph 187, the judge makes quite clear that this part of his judgment is given in case he's later considered to have been wrong on the conclusions that he's reached on the indemnity. And in that scenario, at paragraph 193, the judge concluded that it's impossible to conclude that no reasonable landlord would require a guarantee for the liability of NTRML as assignee, given the importance of the common parts lease. And my learned friend makes the submission, as indeed one would expect, that in effect the question the judge determined, and which I'm asking this court to take a different view on, was a question of fact, and therefore a margin of appreciation ought to be given to the judge's findings in that regard. But we say that there are two matters of principle that affect this conclusion that the judge reached, where the judge went wrong. First of all, the judge omitted to properly take account of the step-in rights of Alma under the common parts lease in his reasoning in this part of the judgment. And secondly, he failed to take into account the disproportionate detriment to the receivers of being saddled with liability under an authorised guarantee agreement, potentially indefinitely, which ought to lead to the conclusion that even if they weren't acting within their powers, the condition requiring a guarantee was an unreasonable one. So, if I can deal, first of all, with the first of those 2 points. At paragraph 190, the judge was positing the scenario which a reasonable landlord in Alma's shoes would also posit, where in the future NTRML might not have sufficient financial resources to perform its obligations under the common parts lease, notwithstanding the right to recoup service charges from the tenants of the flats. And if NTRML failed to perform in the future, the landlord would, of course, retain its step-in rights under clauses 6.2 and 6.7. And the judge then said, sorry, I'll just find it in the judgment. This is the third line of 190. If NTRML failed as a lessee's management company, the losses could be substantial because then the claimant, in exercising those rights, might not be able to recoup 50.58% of its expenditure. And he then went on in paragraph 192 to compare Alma's position if NTRML became the common parts lessee with Alma's position when it first acquired the freehold, when Alma had control over the common parts lessee, which was North Tower Management Company, referred to in the judgment as NTMC. Now, a similar comparison can be made, and it was made in a slightly different context, at paragraph 183 in the judgment, with the position Alma would have been in if an assignment that was proposed a year after the redemption took place to a different company controlled by Alma called Alma Estates Limited had completed. I don't think there's been mention of this yet, so I ought just to explain what happened. It's addressed in the narrative section of the judgment at paragraph 28 on page 51. And by the time we get to August 2017, which is what the judge is dealing with in paragraph 28, the charge has been redeemed and the receivership has ended, but of course the common parts lease remained with the receivers. And the judge records here that the claimant contacted the defendants seeking to tidy up some loose ends, viz. The CP lease and the deed of covenant. Solicitors were instructed on both sides to progress assigning them to a newly incorporated group company of CPC, that's Combined Property Control, which is the controlling entity, that was called Alma Estates Limited. But the matter appears to have been lost sight of on both sides when the defendant's lawyer at Shoesmiths left the firm in June 2018. CP lease remained vested in the defendants, and Landlords Decoy continued to manage. So, as recorded there by the judge, a situation arose where both sides were in agreement that the lease would be assigned to a nominee of Alma, which Alma incorporated. It was called Alma Estates Limited. But that just fizzled out and it didn't happen. The reason the judge puts on that is a solicitor at the defendant solicitors leaving the firm, and it was never picked up. But going back to paragraph 192, it's relevant when considering whether it's reasonable to require the receivers to give an authorised guarantee agreement on assignment to NTRML to compare Alma's position that would have arisen if the assignment to a company which Alma controlled had completed in 2017, just as it is relevant to consider Alma's position when it bought the freehold subject to a common parts lease which was held by a different entity which was controlled by the freeholder, which was subsequently allowed to be dissolved, which led to the disclaimer of the common parts lease. In either of those two scenarios, where the common parts lessee is controlled by Alma, Alma can ensure that it doesn't default. And that's the reason why in paragraph 192, the judge was placing weight on the fact that Alma will have no influence over NTRML when the assignment of the common parts lease to NTRML is completed. And he concluded that Alma was at greater risk of financial loss as a result of the failure of NTRML. Now, so far, so good. But we say that this misses a key part of the analysis, which undermines the conclusion that the judge then derived from all of this. under the structure where the common parts lessee is an SPV controlled by Alma, Alma, or its parent, funds the SPV to carry out the works and relies on, or causes, I should say, the SPV to collect the 58.8% of the share of the cost from NTRML under the deed of covenant. If NTRML is the lessee rather than an Alma-controlled SPV, and NTRML fails to perform, Alma has its step-in rights, which it can exercise, which the judge was referring to, and Alma funds the works itself, and then under clause 6.7 or clause 6.2 claims the appropriate share of the cost from NTRML. Now, the only difference between that scenario, so post-assignment, where NTRML is the tenant, NTRML is failing to perform and Alma's relying on its step-in rights, is that Alma's claim for a share of the costs that it has laid out in carrying out the works is made under clause 6.7 or clause 6.2 rather than by Alma's nominee as tenant under the deed of covenant. And so in that sense, Alma as landlord, if we're looking at the situation which arises where NTRML, its tenant under the common parts lease, fails to perform, is in no different a position financially, because Alma was content to acquire the freehold with the common parts lease vested in its own nominee, which it funded, and it was content in 2017 to resurrect that structure. And if anything, Alma's position is more favourable where NTRML is the common parts lessee, because the default position there is that it's not Alma funding the works. It can rely on NTRML as tenant. And the point was made to the judge and accepted by the judge. NTRML as a company wholly owned by the underlessees of the flats has a direct interest in performing these obligations in relation to the building in which those flats are contained. But if NTRML should default, then in that scenario, Alma's financial position is no different based on the various rights and obligations that it has under the terms of the common parts lease.
I may have failed to follow some of this. I think I might think that as regards the contractual arrangements, but of course if you don't have control of the company, NTRML in this case, you don't know what other liabilities it may have. Well, is that a point being made?
Well, it is a point.
Extraneous liabilities, whereas the SPV is in-house.
Well, it is a point, and that goes to the point that the judge was relying on in relation to this conclusion, the absence of control over NTRML. But what led the judge to this conclusion was the risk of financial loss to Alma. And he said that's the wording that he uses in paragraph 192. If NTRML becomes the tenant and at some point in the future is unable to perform its obligations, and the point your ladyship makes might be a reason for NTRML failing to perform its obligations. But in that eventuality, Alma has the benefit of its step-in rights. And if it has to exercise those step-in rights, financially, it's in no different a position to where it would have been if the lease was vested in its nominee company and it was reliant on the covenant under the deed of covenant to recoup NTRML's share.
Okay, because it always comes back to whether NTRML is good for the money.
And really the only difference is which contractual obligation does Alma have to rely on. And so That we say is where the judge went wrong here. He started along this line of analysis, correctly we say, but he didn't follow it through to what we say ought to have been the conclusion. And when you get to that point, it undermines the conclusion that he reached, that it would be reasonable to require the receivers to guarantee NTRML's liabilities because of the covenant strength of NTRML.
It's another way of putting it is that to require a guarantee so it brings more to the party than anyone ever contemplated. It brings in a covenant, an additional covenant.
Well, indeed,
from that wasn't there in the original structure or in the iterations of it. It would have led to the transfer to another.
Absolutely, and the judge referred to the authority that says that that is not a reasonable basis for requiring a guarantee or imposing a condition. Sorry, it was in relation to his conclusions. It's the very end of the judgment. It's paragraph 201. Mount Eden and Stroudley Investments. And we've got it in the bundle, but the only bit of it that is relevant is the passage that's cited in paragraph 201. And it's the second of the points that was made by the Court of Appeal in that case. It will not normally be reasonable for a landlord to seek to impose a condition which is designed to increase or enhance the rights that he enjoys under the head lease. Your reference, it's tab 10 in the authorities bundle, the authority itself, but that is the proposition, which I don't think is a controversial proposition in itself. And we say that because the judge didn't follow that line of analysis to the conclusion that he ought to have reached, he misapplied that condition in his provisional reasons. He's applying it here in his actual conclusions, taking into account the indemnity, but he ought also to have taken that into account in the section where he was giving his provisional reasons. That's the first of the 2 points of principle. That might be a convenient moment, my lord.
Very good. Are you on track between the two of you to finish by 1 p.m. tomorrow?
I don't anticipate being more than about an hour in the morning. Hopefully less.
I'd be very surprised if I was even a fraction of that. So it looks as though we're well on track.
Very good.
You're bound to be a fraction of an hour, at least.
I'm not saying anything about how big a fraction.
Very good. 10:30 tomorrow.